Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. There has been a ton of huge things that have happened recently in the False Claims Act world. We've got an FCA Supreme Court decision, an FCA circuit split growing deeper with a new First Circuit decision, a huge blow to DOJ in a multi-billion-dollar FCA case against the Medicare Advantage plan, a memo from the Attorney General that purports to narrow up FCA enforcement, and an FCA trial win by SuperValue, the case that went up to the Supreme Court the other year, where a jury found for the defense and cleared SuperValue of FCA allegations. These are huge developments, and we want to get our listeners up to speed on what these new developments are and what they really mean for those who are in industries that involve government claims. And so today's episode is a different kind of one. It's an emptying of the, notebook episode, as some journalists say. We're covering 5 of the biggest FCA developments from the last month or two. And joining me to talk about these really big FCA developments is my colleague, Tanner Cook. Regular listeners will remember Tanner from our episode last year on how Chevron's demise impacts FCA litigation. And we're bringing Tanner back to help us stay on top of these current events, these cutting edge developments. I won't reintroduce Tanner in full, except to say that Tanner is super sharp when it comes to the FCA, especially complex concepts. And we've got some complex concepts to talk about today. So Tanner was my first thought when it came to digging into these new FCA developments. And so Tanner, welcome back. Thanks for getting me and our listeners up to speed on these breaking FCA developments.
Yeah, thanks, Jonathan. Happy to be back. As you noted, there's a lot to cover, a lot of interesting things, and actually a lot that I think is on the horizon. So I think this should be a fun episode.
Yeah, I agree, Tanner. Let's get right into the thick of things. In late February, the U.S. Supreme Court decided an FCA case. This is the Wisconsin Bell case. This case is as complex as FCA comes, at least to me. Tanner, cut through the complexity for us. Give our listeners the streamlined story of Wisconsin Bell, what the Supreme Court said, and how the case impacts FCA enforcement going forward.
Sure, happy to do so. So Wisconsin Bell dealt with, at a high level, the question of what is a claim. And now you would think with a statute called the False Claims Act that's been around for a long time and is heavily litigated, we would have settled that question already, but it turns out we hadn't. So relevant to our discussion here today, the FCA defines a claim in part as any request or demand for money or property where the government has provided any portion of that money or property. So that was the relevant language for Wisconsin Bell. Factually, Wisconsin Bell dealt with this program called the E-rate program that was established by the FCC. And for our purposes, I don't think we need to get too deep into what that involves. Essentially, it's a program that's designed to further universal access to telecommunication services. So the FCC created this program, and to fund this universal access, it required telecommunication carriers to contribute funds to this universal fund to further this access. So these are statutorily required dollars from private entities. And the program is administered by a private nonprofit corporation. So for FCA purposes, the real issue is, okay, you've got private dollars that are required by statute, and you've got a private entity that's administering these funds. How is this a demand for money or property to the government? This all seems like we're dealing with private money and we're dealing with private actors. It doesn't really involve the government. So that was the issue that was teed up to the Supreme Court. And the Supreme Court ruled against Wisconsin Bell and for the relator on this issue. And so in doing so, it really took a narrow view of things. It said during the relevant time period, and that's critical to the decision, the government provided about $100 million at least of its own money to the fund through the form of settlement awards that it collected, delinquent contributions, things like that. And so because that money was collected by the government, held in the treasury, and then submitted to the fund, that was enough to say that during the relevant time period, the government provided at least some portion of the funding. So that settled the issue. It was a 9-0 decision on that. And what is often the case here is what the court said is less interesting than what the court didn't say. So as Justice Thomas noted in his concurrence, the court was reserving ruling on a couple of really interesting issues. One of them being, is this nonprofit private entity that administers the fund, is that an agent of the government? And could that matter for whether or not this is a claim? The other very interesting question is, because these dollars are required by statute. The companies are required by law to submit these dollars to the universal fund. Is that enough to characterize those as government funds? After all, most money begins in private hands and then makes its way to the government, right? We're coming up on tax season, so everyone should be very familiar with that. So the court didn't rule on those. It had a very narrow ruling, which I think is what allowed it to get a unanimous decision. And then the last thing that was not ruled on but was brought up again is the entire constitutionality of the qui tam provision. So as some people might recall, there's a brewing dispute over whether or not the qui tam provisions violate Article 2 of the Constitution. And in 2023, Justice Thomas, dissenting in the Polanski decision, noted that the Supreme Court should take up this issue in an appropriate case. And he was joined in that part of his dissent by Justices Kavanaugh and Barrett. So here in Wisconsin Bell, Justice Kavanaugh concurred separately and again called for the court to take up this issue, whether or not the qui tam provisions are constitutional. And to add to the interest of all of this, he was joined by Justice Thomas, but he was not joined by Justice Barrett. And so it's unclear whether or not Justice Barrett, felt that she had already made her views known on this and didn't need to repeat herself, or if perhaps she's had a change of heart and she doesn't think that this is an issue that the court should take up. So there was a lot that came out of this that is left unanswered, and I think we're walking away from Wisconsin Bell with more questions than answers at this point.
Thanks, Tanner. That's a great summary. Yeah, so Wisconsin Bell is super fascinating to me. The idea that I keep coming back to is, the FCA is a pretty simple statute. If you read the statute, it's meant to deter specific conduct. Going back to the Civil War, when it was passed, it's meant to deter people from blatantly ripping off the government. It's the statement of lawmakers that breach of contract is not enough. You've got to have a bigger deterrent when you're defrauding the government. But I guarantee you, the drafters of the original False Claims Act right after the Civil War had no idea that one day there was going to be this program where the government was going to require private companies to pay into it. And it's going to be a question as to whether that's a claim or not. I think this is really complicated. I agree with the Wisconsin Bell opinion. But as you said, Tanner, there's a lot of interesting stuff that comes out of this that is sort of yet to be decided. I think the takeaway for our listeners, most of the time we're dealing with something far less complicated than the E-rate program. In healthcare, if you're a healthcare provider, you're making a claim to Medicare, that's your claim. If you're a defense contractor, you're making a claim for a bit of the funds that you're supposed to receive, that's a claim. This E-rate program just shows that enforcement in the FCA is getting into some really interesting areas. And so thanks, Tanner. That's a helpful synopsis of this Wisconsin Bell opinion. And like you said, there's a lot more to come. So let's move right along. Next up, we've got the Regeneron case from the First Circuit. This is growing the circuit split on the level of causation needed for kickback predicated FCA cases. For background on this one, in the Affordable Care Act, Congress added statutory text that said claims resulting from kickbacks are FCA violations. That's the key language, resulting from. The issue there is that courts have previously interpreted that phrase resulting from to mean actual causation. In other words, that the claim wouldn't have been submitted but for the kickback. And that's very different from how FCA works with other obligations. Think of it this way. If a drug company visits a doctor who prescribes a bunch of the company's drugs and then hands the doctor, a bag of cash, and the doctor continues prescribing the same drugs as before, has that bag of cash caused any claims? Who's to say the doctor wouldn't have just carried on as before, prescribing the same drugs, regardless of that bag of cash? That's where causation is super important. And Tanner, courts are divided on the Affordable Care Act's resulting from language, and the First Circuit waded into that circuit split in Regeneron the other week. So, Tanner, tell our listeners what the First Circuit said and how it impacts FCA enforcement going forward.
Absolutely. So at a high level, and I think this is really all that anyone needs to know about this, is the First Circuit took the side of the split that says you need to show that but for the anti-kickback violation, the government would not have paid the claim. So that's really the key takeaway. That is the split. Is this a but-for causation standard, as the Sixth and the Eighth Circuits have said? Or is this just some connection? Does there need to be a nexus between the violation of the anti-kickback statute and the claim that's being submitted? That's what the Third Circuit has said. So those are the two sides of the split here, is what people are calling a some connection test, and then what others are calling a but-for causation test. And The First Circuit sided with the Sixth and the Eighth, deepening that split. And so as far as enforcement goes, if you're in the First Circuit and you're dealing with one of these cases, if you're a defendant, you have a much friendlier standard. It's significantly harder for the government to show that, but for this violation, the claim would not have been paid. It's a lot easier if you're in Pennsylvania or New Jersey there in the Third Circuit, where there's just this some connection test. So from an enforcement perspective, this is going to matter depending on what circuit you're in, whether you've got a harder standard for the government or a relator to prove or an easier standard. And then, at a broader level, what this means is that we're likely to see other circuits weighing in on this. And circuit splits typically go, this is going to proliferate and we're going to get differing views. And presumably at some point, the Supreme Court might step in and clear it up. But right now, we've got really irreconcilable standards that are vastly different from each other, both in terms of what the governments and relators must prove, and then also relatedly how defendants go about defending a case. So I think that's what the main takeaway is on this, is that it's highly dependent on what circuit you're in and what the standard is going to be.
Yeah, I think that's all right, Tanner. Yeah, I think what's interesting, there's nothing from the legislative history that said Congress was trying to elevate the causation standard here, but words have meaning and Congress chose these words. And so we've got to apply the statutes as they come. So I think we're general on this is the right decision. Congress is free to go back and change it. And if they don't like this, if this was unintended, and I think it was, they can go back and change the law. That's perfectly something that they can do. But I think Regeneron gets it right because this is resulting from, has been interpreted to mean but for causation. That's what it's meant always. And so I think this is the right decision, even though there's no sign that Congress intended to create this new standard in the Affordable Care Act. But again, words have meanings. What's interesting here is I've got some friends on the relator side, and when this First Circuit opinion came out, they texted me and they said, hey, what do you think about healthcare providers that make claims themselves? Is there still like an implied false certification theory that fits within Regeneron? I think the answer probably is yes. It's interesting to read it. The First Circuit sort of acknowledges that that is an independent theory, but doesn't actually say whether it would apply or not. It wouldn't have changed the outcome in Regeneron, but I think that's an uncertain area coming out of this. And because of that, and because of this growing circuit split, Tanner, I think we're going to see cert granted at some point on this. I mean, this is too important of an issue. So I think that's probably going to come at some point. But the big takeaway, and I've told some healthcare providers this just in passing in the last week or two, don't pay kickbacks. Just because there's this new defense-friendly way of arguing False Claims Act cases that are predicated on the anti-kickback statute, that does not mean that you should pay kickbacks. Just don't do that. This is something that, Tanner, you and I care a lot about and our fellow False Claims Act practitioners. But if you're a healthcare provider, if you're a defense contractor, whatever you are, don't pay kickbacks. This is not an invitation to go and pay all the kickbacks because that's just a bad idea. Tanner, thanks for catching us up to speed on this growing circuit split. So let's move along to this big defense win in the United Health case from just a couple of weeks ago. For the past decade, DOJ has been warring with Medicare Advantage plans over how they adjust for risk. Way oversimplified, Medicare Advantage plans are paid by the government to offer health plans for Medicare patients, and the patients are increased or decreased based on patient diagnoses. So Medicare pays a plan more money to insure a super sick person than it would to insure a super healthy person. Makes sense, right? Here's where it gets complex. Years and years ago, health plans started scouring patient charts to add diagnosis codes in an effort to increase their risk-adjusted payments. But these were mostly efforts to add codes, to increase revenue, not to delete diagnosis codes that were inappropriate. DOJ has called this a one-way look, and they have said that this is improper. Medicare Advantage plans strongly disagree. There's been a bunch of cases on the issue, and one saw a big decision go against DOJ a couple of weeks back in the United Health case. So, Tanner, tell our listeners about the special master's decision in this case, what it means for Medicare Advantage FCA enforcement, and whether there are any broader takeaways for FCA enforcement in general.
Absolutely. So this was for the procedural posture. These were cross motions for summary judgment. The defendant had moved for summary judgment on the theory that the government could not prove the elements of its claim. It's a typical thing that you'll see from FCA defendants. Almost all the time you'll move for summary judgment in these types of cases. But the theory here was very interesting. It was that the government hadn't done the necessary discovery to even come up with any sort of material issue of fact here. And so getting to what you were saying, Jonathan, about these diagnosis codes. The government's theory here was that when a provider submits its diagnosis codes and then the Medicare Advantage program engages in what's called a blind review, where it does its own review of the patient's history and comes up with its diagnosis codes, if the blind review doesn't yield the same codes as the provider, that means necessarily that the provider's codes were inaccurate and they shouldn't be billed. And they were saying that by billing for both the codes that they got in the blind review and the provider's codes were false and they were submitting those to the government. So one of the things the government did not do in this case is actually look at those patient files and compare them to the diagnosis codes to see whether or not the diagnosis codes were actually inaccurate, and instead relied on this assumption that if the blind review didn't catch it, then the provider's code must have been inaccurate. One of the really fatal things for the government here was that the government's own expert admitted that there were all sorts of reasons why a blind review might not pick up accurate codes that the medical provider would put in there. So that eliminated any sort of argument from the government based on this assumption that they were necessarily false. Their own expert said they're not necessarily false. There's a lot of reasons why those might not get picked up. And that was the crux of the special master's decision. It said without actually reviewing the medical files and looking at whether or not these diagnosis codes are actually inaccurate, you cannot prove that there was a submission of a false claim. So that seems like a fairly straightforward ruling. We'll see what happens in the fallout from it with any sort of appeal or what's going to happen in other cases. One thing that I thought was very interesting about this case, and that's kind of flown under the radar because it was such a big victory, the special master also answered the question of whether or not materiality is an element of what's called a prong to reverse false claim. And so we're getting very deep into the weeds of different types of theories of False Claims Act violations. But in section 3729A1G, there is what's called the reverse false claim provision. So a typical false claim is you submit a demand for payment to the government looking to get money from the government. A reverse false claim is where you owe money to the government and you are trying to keep the government from getting that money. And so there's two prongs to this. And the second prong, I'll read from the statute here, is it imposes liability on those who knowingly conceal or knowingly and improperly avoid or decrease an obligation to pay or transmit money or property to the government. So you'll notice in reading that, I didn't say the word material, right? Material doesn't appear anywhere in that prong two, whereas it appears in other parts of the statute. It's even in the first prong of subsection G there. So the government had moved for partial summary judgment on the theory that prong two reverse false claims do not require a showing of materiality. And actually, the government had a lot of case law to back this up. Other courts have addressed this and said, yeah, this doesn't include the word material. Material is used in other parts of the statute. There's no materiality requirement. The special master disagreed. The special master reviewed the Escobar opinion, which is the leading Supreme Court opinion on materiality, and noted that the Supreme Court based its ruling on the fact that the FCA is inherently an anti-fraud statute and that it takes its roots in common law. And at common law, materiality is always an element of fraud, no matter what the theory of fraud is. So the fact that it wasn't included in this particular statutory text doesn't mean that the government doesn't have to prove this. So this is actually a new issue. Until now, at least as far as I know, every court has said that materiality is not an element of a prong two reverse false claim. So the special master is the first one to say otherwise. And this is going to, I think, create a lot of confusion, I'll say, because the typical materiality factors don't necessarily map on in an easy way to a reverse false claim. So for our listeners, the three factors you'll hear most often are whether or not the condition was an express condition of payments, whether or not the government typically denies payment when someone violates this provision, and whether or not the condition goes to the essence of the bargain. Now, that all makes sense when you are submitting a claim for payment to the government. But when you've got an obligation to pay that you're concealing, those factors don't really correlate. So it's possible we just need a new set of factors. It's possible that, the special master just reached the wrong result on this, and that's going to get corrected. And then there's also another issue of, if we use materiality in parts of the statute, but not others, doesn't that make the parts where we use it redundant? And doesn't, for all the statutory interpretation folks out there, isn't that a big problem? I'm not one of those people, so I'll defer to them. But I hear them say that when you use the term somewhere and don't use it somewhere else, that's like mutually exclusive. So I think that's going to be one of the unintended consequences of this decision is it's going to create a lot of confusion about whether or not materiality is required for prong 2 reverse false claims.
Thanks, Tanner. Reverse false claim litigation is a really fascinating area. I know, Tanner, you and I have dug in on reverse false claims a good bit. It's sort of an underdeveloped area of FCA enforcement. And it's really important because we have a lot of healthcare clients and they come to us and they say, well, look, we think we've done something wrong and someone realized it and someone else didn't. And, do we have this reverse false claim problem? And the answer is not nearly as clear as some would think it is. Reverse false claims case law is really sort of interesting to track. We will do a whole episode on reverse false claims at some point. I've been thinking about that for the better part of a year now, how to explain reverse false claims in a sort of helpful way. But Tanner, you did a great job of sort of giving a high-level overview of what all of that entails. So thanks for that. Yeah, I keep coming back to this thing. The drafters of the False Claims Act would just be amazed that we're having conversations about, one-way looks for Medicare Advantage programs. Not at all what the drafters thought this was going to be, but here we are. All right, so next, Tanner, we've got Attorney General Pam Bondi's February memorandum that deals with sub-regulatory guidance as an enforcement predicate. Regular listeners may recall our episodes with Cormac Connor right before President Trump took office, in which we talked about the Brand memo from the first Trump administration. The Brand memo told DOJ not to use sub-regulatory guidance in enforcement, not to base enforcement on sub-regulatory guidance requirements. In other words, let's keep criminal and FCA enforcement in the statutory and regulatory world rather than digging into some guidance document that hasn't gone through notice and comment. The Biden administration reversed the Brand memo, but now General Bondi has more or less put it back in place. Tanner, I think this is a big deal in healthcare enforcement because a fair amount of healthcare payment decisions turn on details contained in coverage determinations, whether national or local. And so, Tanner, tell our listeners what General Bondi's memorandum means for FCA enforcement.
Yeah, well, I'm really excited to talk about this because I think this relates actually to the last episode that we had together where we talked about Loper-Bright and its effect on False Claims Act litigation. And to me, the Bondi memo is really just codifying what Loper-Bright instructed at a general level, and it's codifying it in the FCA context. So for background, right, there's different types of regulatory guidance, some of which is binding and has the force of law. Here, we're focused on a different kind, which is the regulatory guidance that is not binding and does not have the force and effect of law. And what the Bondi memo is really doing is saying that latter sort of guidance, the kind that is not binding and does not have the force and effect of law, that cannot be the basis for FCA violations. And that's really very similar to what we took away from Loper-Bright, which is the agencies are bound by the statute. And at any time they really deviate or go farther than either the text of the statute or their delegation provision that allows them to make rules, when they stray from that, they're acting outside their authority and using the guidance that they issue when they're acting outside of their authority to sort of bootstrap a violation of a non-binding regulation into a violation of the False Claims Act. That's a problem. You're elevating what doesn't have the force and effect of law into something that does have the force and effect of law. So it was very interesting to see this memo come out because I do think that it is perfectly consistent with what we saw in Loper-Bright. I think actually this is the logical outgrowth of Loper-Bright, is that you cannot rely on this non-binding regulatory guidance in order to establish violations of a law. And actually, we saw this already in some cases. So in the Sheldon case out of the District of Maryland, which was the first case really grappling with Loper-Bright in the FCA context, the court noted that relying on non-binding guidance for establishing falsity or scienter is a real problem in the wake of Loper-Bright because the statute always controls. And anytime you've got something outside the statute that is not allowed to conflict with it, you cannot use that to, as I said before, bootstrap that into a violation of the False Claims Act. So this is very interesting to see. It will be equally interesting to see how much this is followed by the DOJ itself and its own False Claims Act decision. So there's a lot that remains to be seen on that. But I thought this was a perfect outgrowth of the Loper-Bright decision. I think that it makes total sense in terms of what the Supreme Court has instructed.
Thanks, Tanner. I agree with you there. Yeah, I keep going back to this. False Claims Act is meant to deter fraud, not just any fraud, knowing fraud, not even an all-purpose anti-fraud statute it is. It is for deterring actual fraud knowingly committed against the government. And when we're getting into guidance documents, local coverage determinations, and the like, we're not really dealing with fraud. It's interesting because a lot of, say, Medicare decisions are to make payment are premised on coverage determinations. And so you're getting down below regulatory requirements into the really fine details of what it means to submit particular CPT codes. And I just think it's hard to say that that's fraud when you're getting down into the weeds of something. And so, yeah, I think that's what this is. I think that's what General Bondi is trying to say is, look, there's a whole world, there's a lot of mechanisms for the government to get into the weeds on particular payment decisions. There's Medicare audits, appeals, ALJs. There's no reason these agencies can't bring breach of contract actions against people that are doing business with it. I mean, there's all sorts of unjust enrichment. There's all sorts of things you could do. Not everything's fraud. Some things are just, hey, we're going to disagree as to whether this particular CPT code is proper or not, and we're going to go fight that out in court. But just because the False Claims Act is this big tool doesn't mean you should use this tool for everything. I think that's what General Bondi is trying to get at. So that's a big development in our world, Tanner, and I appreciate you sort of calling that out for us. All right. Last thing on our list of big cutting-edge developments recently, everyone in the FCA world knows about SuperValue. The Supreme Court decision from a couple of years ago, the Supreme Court sent that declined qui tam back down for trial, and that trial happened. It started in February, it ended in early March, and the SuperValue facts are really complex. It deals with prices that pharmacies were reporting as their usual and customary prices. The question was whether standard discounts fell into the definition of usual and customary prices. Frankly, it's a concept to me that does not sound like fraud, but the whistleblower got to go to trial on it. And the key defense theory was that the defendant's people had no intent to present false claims. And the defense actually lost on that theory. But the defense won on a different theory. The jury said that even though SuperValue knowingly caused false claims, the government sustained no damages because of the way Medicare's Part D program works. Tanner, this is another one where we could go way down the rabbit hole on complex facts and the complicated regulatory scheme, but drill down to the most important things for us and tell our listeners how this trial impacts FCA enforcement overall.
Yeah, I think what's so interesting about this, just as background, is, as you noted, this has been a case for a long time. Went up to the Supreme Court on this issue of scienter, of what it means to knowingly submit a false claim. And we got really the groundbreaking decision from the Supreme Court about how scienter is about your subjective knowledge. Do you think that you're doing something wrong? Do you think you're defrauding the government? So that was what we got from the Supreme Court. And then it goes back down, goes through trial, and the jury says, yes, we think that you knew you were doing something wrong. We think you had the intention of defrauding the government. But it ended up being this sort of no harm, no foul situation because there were no damages to the government, as you noted. And that's actually an element that is overlooked a lot of times in FCA litigation. We focus a lot on falsity, focus a lot on materiality, and now after SuperValue, we're focusing a lot on scienter. But there is this requirement in Section 3731, subsection D, that says, in any action brought under the False Claims Act, the United States, or if it's a relator, the United States standing in the government's shoes, shall be required to prove all essential elements of the cause of action, including damages, by a preponderance of the evidence. And so oftentimes we would see a finding of, I guess, what you could call substantive liability in terms of the other elements, saying that, yes, you submitted a false claim, but the government or a relator still fails because they can't prove damages. And sometimes that's because there simply were no damages. Other times that's because the government cannot actually calculate damages to a reasonable certainty. So we've seen that in some cases as well, where there's been a trial and it's found that the defendant submitted false claims to the government. It's actually been found that the government probably was damaged in some way, but without a calculation that's reliable as to what those damages actually are, we've seen awards of $0. And so I think this is just a good reminder that you need to focus also on the damages element. It's not listed in 3729 because it's sort of almost goes without saying because this is about costing the government money. But a lot of times, we're so focused on falsity and scienter and materiality that we overlook that there's this other aspect, which is, did this actually damage the government? And can it be shown to what extent those damages actually took place? So I think this is just a great lesson about kind of looking at the totality of the statute and what all the elements are that need to be proven by a preponderance of the evidence.
Thanks, Tanner. I totally agree. So me selfishly, I happen to think there should be a lot more False Claims Act trials. I think trials are really good for developing law because you get to see what sort of cases should be brought, what sort of cases shouldn't be brought. So I think trials in general are good. The issue I have is in the False Claims Act, trials are enormously risky. I don't think I can, in good faith, tell a client, yeah, go risk bankruptcy or losing your company to go try this theory because we may not win. If we're going to trial, it means we've lost on summary judgment. And so there's some question of fact here. And if there's some question of fact, you're biting off so much risk. For example, there was a False Claims Act trial in Minnesota 2 years ago where there was $43 million in false claims identified. The defense thought they were going to win that. Because of trebling and per claim penalties, that ended up being a $487 million judgment. Luckily, the judge in that went back and said, look, I've got excessive fines clause concerns with this judgment. I'm going to reduce the penalties by 82% in order to make sure that we're complying with the Constitution. But that's such a deterrent to going to trial is when you're sitting there not knowing if the judge is going to buy your excessive fines clause argument, not knowing if you're going to lose control of your company. I've got several friends who got up to the brink of an FCA trial and they stopped because they said, this is an existential threat. This is not worth the risk. So me personally, I love that FCA cases are going to trial. I think we all learn. We're going to learn a lot from this super value trial and see how jurors respond to these complex issues. And so, Tanner, me selfishly, I'm very thrilled that this went to trial because I think it's good for us who are defending these to see what it's like when this gets in the hands of jurors. So, Tanner, thanks for talking about that case with us. And thanks for joining us to talk about these really cutting edge issues.
Yeah, that was a lot of fun.
To sort of close, these are 5 really big developments in the FCA. They're all coming within the last 2 months. Everything seems to be happening at a pretty quick pace now, and the ramifications for all these things are huge. In this sort of climate where things are happening so quickly, you've got to have sort of accomplished and knowledgeable lawyers on your side who know this area really well. I hate to think of there are people under investigation right now who could help their clients go to DOJ and say, hey, there's this new memo from Attorney General Bondi that says you can't look at sub-regulatory guidance. All of your facts are dealing with sub-regulatory guidance, so let's figure out the application of this memo. You've got to have lawyers who know how to bring these issues up. And so that's why I'm fortunate to work with Tanner and so many of our other colleagues who are keeping on top of all of these cutting-edge issues, because this is how we defend our clients, is knowing the law as it is right now, and the law is changing very quickly in the False Claims Act lately. So that's our episode for today. We appreciate you all listening to our episode today. Continue to listen to us as we bring you more cutting-edge FCA developments. I hope you enjoyed the discussion. Thanks for listening, and we'll see you next time.